When New Hampshire ratified the Constitution, whatever Virginia and New York did, the Constitution was going to go into effect in March of 1789 between the states that had ratified. New York had to come to its own decision whether to remain aloof from the Union or to join. As with all of the later states that had close votes on the Constitution, the powers of the federal government were a highly debated topic.
Montesquieu, with all the examples of modern and ancient republics in view, gives it as his opinion that a confederated republic has all the internal advantages of a republic, with the external force of a monarchical government.
Here we have another founder who was citing Montesquieu. The hope was that this Constitution would give the people of the United States the benefits of small republics as well as the benefits of large empires, without the weaknesses of both.
Can any reasonable man be well disposed towards a government which makes war and carnage the only means of supporting itself? A government that can exist only by the sword. But can we believe that one state will ever suffer itself to be used as an instrument of coercion?
Hamilton was an advocate of ratification. Here, he is questioning whether a state would allow itself to be used to coerce the other states.
In forming a constitution for a free country like this, the greatest care should be taken to define its powers and guard against an abuse of authority. The Constitution should be so formed as not to swallow up the state governments. The general government ought to be confined to certain national objects, and the states should retain such powers as concern their own internal police.
John Williams was an opponent of ratification. Here, he is arguing that the federal government will define its own powers and that then will swallow up the states, and therefore the Constitution should not be ratified.
In the proposed Constitution, the legislature is controlled by various checks and balances, and by the vigilance and weight of the state governments. To talk of tyranny and the subversion of our liberties is to speak the language of enthusiasm. This balance between the national and state governments is of the utmost importance. It forms a double security to the people. If one encroaches on their rights, they will find a powerful protection in the other. Indeed, they will both be prevented from overpassing their constitutional limits by a certain rivalship which will ever subsist between them.
Here, Hamilton is arguing that the resistance of the states is an important part of the system, and keeping the federal government and the states within their proper bounds makes this system safe to ratify.
The most powerful obstacle to the members of Congress betraying the interest of their constituents is the state legislatures themselves, who will be standing bodies of observation, possessing the confidence of the people, jealous of federal encroachments, and armed with every power to check the first essays of treachery.
Governor Clinton is saying that when Congress goes beyond its enumerated powers, it is betraying the interest of their constituents and committing an act of treachery.
The rights of a state are defined by the Constitution and cannot be invaded without a violation of it. The gentlemen are afraid that the state governments will be abolished. But, sir, their existence does not depend upon the laws of the United States.
The rights of the state are defined by the Constitution insofar as it limits the federal government from abusing them. An invasion of the rights of the states is a violation of the Constitution. Also, states had rights before the formation of the Constitution. State powers existed independently of the Constitution and prior to the Constitution.
In the preamble, the intent of the Constitution, among other things, is declared to be to provide for the common defense and promote the general welfare. And in the clause under consideration, the power is in express words given to Congress to provide for the common defense and general welfare. There is an express authority to make all laws which shall be necessary and proper for the carrying into execution this power. It is therefore evident that the legislature, under this Constitution, may pass any law which they may think proper.
John Williams opposed ratification because he said that the legislature will apply what my civics teacher's interpretation of the necessary and proper clause. Because he felt that Congress would say, we can do anything we feel is necessary and proper, for that reason, John Williams opposed ratification.
The powers granted by it, the taxing clause, were indefinite, since the Congress are authorized to provide for the common defense and general welfare, and to pass all laws necessary for the attainment of those important objects. Now, if the Congress should judge it a proper provision for the common defense and general welfare, that the state government should be essentially destroyed, what, in the name of common sense, will prevent them? Are they not constitutionally authorized to pass such laws? Are not the terms, common defense and general welfare, indefinite, undefinable terms? What checks have the state governments against such encroachments?
2 days later, John Williams explained that he opposed ratification because Congress will cite the general welfare to justify any law they want, and the states will have no power to stop them. Therefore, he opposed ratification.
The laws of Congress are restricted to a certain sphere, and when they depart from this sphere, they are no longer supreme or binding. In the same manner, the states have certain independent powers, in which their laws are supreme.
Hamilton is talking about what historian Forrest MacDonald called imperium in imperio. Each body is supreme within its own sphere. The general government is supreme within its sphere, and the states are supreme within their sphere.
The laws of Congress are restricted to a certain sphere, and when they depart from this sphere, they are no longer supreme or binding. In the same manner, the states have certain independent powers, in which their laws are supreme.
Livingston here says that whenever the Congress goes beyond its delegated powers, its decisions are no longer supreme or even binding, and within their sphere, the states are supreme.
Respecting the power to make all laws necessary for the carrying the Constitution into execution, provided that no power shall be exercised by Congress, but such as is expressly given by this Constitution. And all others, not expressly given, shall be reserved to the respective states, to be by them exercised.
John Lansing proposed an amendment to the Constitution which would make it clear that the necessary and proper clause did not go beyond those powers expressly enumerated to it.
The powers of government may be reassumed by the people, whensoever it shall become necessary to their happiness. That every power, jurisdiction and right, which is not by the said Constitution clearly delegated to the Congress of the United States, or the departments of the government thereof, remains to the people of the several states, or to their respective state governments, to whom they may have granted the same.
New York ratified the Constitution on July 26th. A couple of caveats are in place. First, New York explicitly declared that the people may resume the delegated powers whenever they feel it is necessary for their happiness. Further, the federal government powers are clearly delegated and may not go beyond those powers.
Those clauses in the said Constitution, which declare that Congress shall not have or exercise certain powers, do not imply that Congress is entitled to any powers not given by the said Constitution, but such clauses are to be construed either as exceptions to certain specified powers or as inserted merely for greater caution.
The other caveat was that the New York ratification instrument included a statement that the Constitution, Article 1, Section 9, states that Congress shall not exercise this or that power, but that clause does not mean Congress has any powers beyond those expressly delegated. Article 1, Section 9 is merely inserted for greater caution. The New York vote was 30 to 27. As with other states that ratified the Constitution late in the overall process and by close votes, advocates of ratification had to convince the skeptics that this Constitution was safe to ratify. They did that as advocates in other states had done, by assuring the skeptics that the federal government would only be allowed to exercise those powers that were expressly delegated to it, and the federal government could never go beyond those powers. So the Constitution was safe to ratify.